Welcome back. Time for our Law and News segment, sponsored by Gig and Jancola. We've got attorneys Mike Gig and Chris Jancola with us. Hi, guys.
Hi there. Good morning.
It's always good to see you. Chris, for people that don't know, what type of law do you both specialize in?
All right. Well, I do personal injury, workers' compensation, Social Security, disability. Mike does a lot of our wills, estates, real estate, so a little bit of everything.
Yeah, this is exciting because we've been taking questions for a long time now. You can just send your emails to the Law and You email, and today we've got a really great one, so let's get right to it. I am renting a half double. My furnace went out and I contacted my landlord on October 30th to let him know. I wanted to contact a local repair shop, and I was told that they actually had someone to fix it. Their maintenance guy showed up, took off the part, and said he ordered the part that they had and they just have to wait for it to arrive. Well, that was 2 weeks ago, and we're still sitting here with absolutely no heat. I have electric heaters running and my oven. Can I hold rent until this is resolved? And can I deduct from the rent the increase in my electric bill that will obviously be outrageous? That's a good question.
It is a good question. So in Pennsylvania, every lease, whether it's a written lease or just an oral lease, because you can have either one, there's what's called an implied warranty of habitability. Okay, so very simply, you have to ensure, you don't have to have a perfect, landlord doesn't have to provide a perfect place for you to live, but it has to be habitable. So there has to be running water, in this case, a furnace going out, so a leaking roof. So the warranty of habitability has to do with major things with the rented space. So that would be if there's a leaking roof, if there is a furnace that goes out in the cold months. So what I would advise people to do, and what you should do under the law, is first contact your landlord, but I would do it in writing. So I would send them a letter. I would probably do it certified, so they ensure that, later on, if this goes to a hearing, to ensure that they got it. State the problem of what's going on, what you plan to do as the tenant if they don't fix it. It can be a case-by-case basis. If it's something like this, if it's below zero out and your furnace goes out, that's an emergency. So you can't, I'd give them at least probably 20, even if it's a major emergency, probably give the landlord at least maybe 24 hours to resolve it. But tell them in the letter that if they don't, that you're going to contact someone to resolve it. Now, if you do that, if the landlord doesn't do anything and you have to pay them to fix it, you can deduct the amount of rent or whatever you pay to fix that. You can deduct that from your rent.
You can.
You can.
Now, would that have to be in the letter?
Yes.
That you're telling your landlord, you're saying, okay,
yes,
if this is how much, I've been, charged, and I'm going to deduct that from the rent.
Right, and the other thing under the law is that they have to be reasonable costs. So it wouldn't be, for instance, if the furnace goes out, not that you would want to pay this, but you wouldn't go and get a whole new furnace and then say I'm going to deduct 6 months of rent from that. It has to be what's reasonable to get the issue corrected. But the point is you can deduct it. Now the other thing that can't happen is, which I have seen these cases where you do something like this, you hold back rent, and then the landlord turns around and evicts you or files for an eviction.
Oh my goodness.
So that would be a retaliatory eviction, which you cannot do. But that's why.
So then could you reach out to a lawyer in terms of some type of retaliation?
Yes, but that's why, like everything that we deal with, you want to have everything in writing. So you want to have that letter sent to the landlord proving that you sent it to them, they were notified, they received it. Of course, receipts of all the costs that you incurred.
So that's basically what we're telling the viewer right now, is that they should be sending that letter now.
Right.
Because they've been waiting 2 weeks, still hasn't been fixed.
Right, and to be honest, if it's an emergency and you know where the landlord is, have somebody deliver the letter directly to them so it doesn't take a couple days for them to get the letter if it's an emergency. But the biggest thing is you need to notify the landlord, and the landlord has to have an opportunity to correct it. You have to give them that opportunity, even if it's a short period of time, because if you don't, landlord could later come back and use that against you and say, listen, you gave me no opportunity to fix it, and now you're saying the rent should be deducted. So you have to give them that opportunity.
So it sounds like it is open communication, but of course all documented communication.
Yes, correct. That's right.
Wonderful. Chris, if people want to reach out to you and Mike, maybe they've got more questions or they want to talk about workers' comp, things like that, best way to reach you?
Yes, please give us a call at 814-946-1606 or go to gig-law.com and click on the Contact Us button.
Wonderful. Thanks so much, guys. We'll
Thank
see you
you.
Thursday.
Thank you.
We've got a lot more stuff to come, including this. We're going to take you to Du Bois Granite and Quartz.